So one of the considerations for consent is appropriate consent. In terms of living adults with the capacity to consent, then appropriate consent would be from the individual concerned. With regard to living adults who lack the capacity to consent, the Act makes it lawful in certain circumstances to store or use tissue, where the tissue is actually from an adult who lacks capacity to consent, and where consent can be deemed to be in place. For research purposes, these circumstances are for the purposes of a clinical trial authorised and conducted under the UK Medicines for Human Use Regulations 2004, or when the research is allowed under clauses 30 to 34 of the Mental Capacity Act, which came into force in October 2007. In the cases of adults lacking the capacity to consent, consent should be obtained according to the local legislation. The Mental Capacity Act 2005 in England and Wales, and the Adults with Incapacity Act Scotland. For living children, under the Act, a child is defined as being under 18 years old. If a child is considered competent, then consent should be sought from the child. It's always good in practice to involve persons with parental responsibility in the process of consenting children. Regarding deceased adults, consent is appropriate from the individual if their consent can be given whilst they're alive and competent. If the individual did not make a decision to consent or refused to consent prior to death, but did appoint a nominated representative, consent for research can be obtained from the nominated representative. If the deceased individual did not appoint a nominated representative, appropriate consent can be sought from a person in a qualifying relationship. And that's according to the following hierarchy, with the highest ranking first, which is the spouse or partner, followed by the parent or child, then the brother or sister, then a grandparent or grandchild, then a niece or nephew, followed by stepfather or stepmother, then half-brother or half-sister, and finally a friend of long standing. For deceased children, consent is appropriate from the child if given whilst alive and considered competent. If the child did not make a decision or was not competent, the appropriate consent should again come from a person with parental responsibility. If there is no such person, consent can be sought from someone in a qualifying relationship as described above. Regarding consent from children and adults lacking capacity, it's important to consider that individuals that are unable to consent to participation in a research project due to a lack of mental capacity are a particularly vulnerable group, and their interests must be protected. They should be given the same opportunities to participate in ethically designed research projects as those who do not lack capacity, but they must not be put at any unwarranted risk. Their participation needs to be agreed by someone who is independent of the study and who can assess the potential participants' interests in accordance with the current legislation and guidance. This person may be a relative, carer, or an independent representative. With respect to children, it's considered that children may consent to a proposed medical procedure or the storage of their tissue if they're competent to do so. In the case of Gillick, the court held that a child was considered competent to give valid consent to a proposed intervention if they had sufficient intelligence and were able to understand fully what was involved in the process. The Act does not specify the criteria for considering whether an adult has capacity to consent, but under the Mental Capacity Act, they are considered to lack capacity if they cannot do one or more of the following things: understand the information given to them that is relevant to the decision, retain that information for long enough to be able to make the decision, use or weigh up the information as part of the decision-making process, and communicate their decisions by any means. The first core principle of the Mental Capacity Act is that an adult must be assumed to have capacity to make decisions for themselves unless it's established that they lack capacity. In terms of validity of consent for research, the giving of consent should be considered as a positive act. For consent to be valid, it must be given voluntarily by an appropriately informed person who has the capacity to agree to the activity in question. For consent to be valid, the person should understand what the activity involves and, where appropriate, what the risks might be. To ensure that the removal, storage or use of any tissue is lawful, it's important to establish clearly that consent has been given. Consent may be expressed in various ways and does not necessarily need to be in writing, unless the Act requires it to be so. As I mentioned previously, this would be true in the case of anatomical examination or public display, in which case consent must be in writing. For other purposes, the information required and the manner in which consent is obtained and recorded may vary depending on the circumstances, but records for research should generally include details of who gave the consent, exactly what the consent related to, and any restrictions that might have been imposed on the use of the samples, the processes that will be applied to the tissue, if a tissue is transferred, when and to whom, and when and where the disposal is undertaken, if relevant. Regarding the scope and duration of consent, as we mentioned before, this may differ. It may be generic or it may be specific. Enduring consent means that it remains in force until the consent is withdrawn. A person may, however, specify a time limit for how long they wish their consent to remain in force. In both cases, the decision should be clearly documented in the patient's records and the laboratory records, or both. The Human Tissue Authority encourages the taking of informed, generic and consent at the outset as the default position, as we've mentioned several times before. Regarding withdrawal of consent, this can occur at any time, whether the initial consent was generic or specific. Withdrawal should be discussed at the outset when the consent is being sought, and the practicalities of withdrawing consent and the implications of doing so should be made clear. For example, potential recipients, what will happen if the donated tissue is for clinical use? Withdrawal of the consent cannot be effective where tissue has already been used, and the donor should be aware of this at the time of giving consent. If someone gives consent for their tissue to be stored or used for more than one scheduled purpose and then withdraws consent for a particular purpose, for example research, this does not necessarily mean that the sample or samples have to be removed or destroyed. However, the samples may no longer be stored or used for the particular purpose for which the consent has been withdrawn. In addition, if someone withdraws consent for samples to be used in any future projects, this does not mean that the information and research data should be withdrawn from existing projects.